I'm getting questions about false imprisonment or false arrest in regards to the Leon Valley incident, and it's a really big question, and the answer is probably no. And I'll tell you why the answer is probably no. This is a unlawful restraint, Texas Penal Code 2002. Person commits an offense if he intentionally or knowingly restrains another person. That's basically arrest. However, there's justification generally. Public duty, except as qualified by sections B and C, conduct is justified if the actor reasonably believes the conduct is required or authorized by law. And so it's reasonably believes. It's all about reasonable belief. And then if you go down to use of force, again, it's reasonably believe the arrest or search is lawful, etc. So it's hard to get it under a criminal code because all the first of all, you have to convince the prosecutor to bring charges. And I would posit to you that that is going to be unlikely unless there is some really egregious action on the part of the police. Like if, and I know you think this is egregious, but I will bet you a shiny brand new nickel that Salvaggio talked to whatever prosecutors he needed to talk to figure out if it was something he could do. I almost guarantee it. Like I said, a shiny brand new nickel. So I don't think prosecutors are going to bring charges. I don't think even I don't the situation does not appear to me to be one where it would apply. Now, the big question is, could you sue over it? And that means you're most likely going to be in 1983 lawsuit territory. 1983 lawsuits are federal. I didn't see a whole lot of ways to do it under state law, but again, I am not in Texas, so talk to a Texas attorney. There may be ways to do it. This is the estate of C.A. Minor v. Paul Castro. This is a 2013 decision from the Fifth Circuit, which obviously covers Texas. Individual defendants' qualified immunity. Qualified immunity was made up basically by the court, by the federal courts. So it only applies to federal lawsuits unless the state has adopted it. But this is specifically a federal kind of idea. And since the 1983 lawsuit is a federal action, then there you go. State actors sued in their individual capacity under 1983 are entitled to qualified immunity insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Qualified immunity gives government officials breathing room to make reasonable but mistaken judgments about open legal questions. When properly applied, when qualified immunity is properly applied, it protects all but the plainly incompetent or those who knowingly violate the law. It is not a speed bump. It is a barrier to prosecution or to recovery. After a defendant invokes qualified immunity, the burden shifts to the plaintiff to demonstrate the inapplicability of the defense. We apply a two-pronged test in evaluating the applicability of the defense. The plaintiff first must claim that the defendants committed a constitutional violation under current law. Second, he must claim that the defense actions were objectively unreasonable in light of the law that was clearly established at the time the actions complained of. So, if I understand the questions correctly that I am being asked, it is unlikely that any of these officers are going to have a real concern of facing a 1983 lawsuit. That is my best understanding at this point. Obviously, if you are in a position where you think you have been affected by this, talk to a local Texas attorney, preferably one who specializes in 1983 lawsuits for rights violations, specifically unlawful arrest or something along those lines. They will be able to guide you much better than I can sitting on my couch in California. So That is a big caveat, but that is my best guess of the nature of the situation at this point. Your mileage may vary. Thanks for watching. Have a great day.